Without further ado, I'd like to turn it over to our speaker this evening, Paul Gantner with Eamon Gantner and Capriano.
All right, thank you, Ann. I appreciate it, and always love to do these events with the great team you have there at the Arc. So we're going to talk about estate planning basics, essentially for families of young children. As Ann mentioned, excuse me, I am Paul Gantner of Eamon Gantner and Capriano, and you know, parenthood's not the same as it's always been for generations. I feel like there's always been lots to do, but if you're like my family, who I'll introduce you to a little bit later, we're always running off to soccer games or dance teams or ballet, and sometimes we have blended families or adopted children or stepchildren, and a lot of really unique situations. In fact, many families have many more people with children under 6 actually have their children being raised by people that are not their parents. So we're going to talk about a lot of different situations that you may not have thought about, or situations that you have thought about and just haven't known what to do about it. And should be plenty of time for questions. And I hope everybody learns some good things. As I said, we spend a lot of time away from our kiddos, and a lot of times that means if you have young children, there's an opportunity, unfortunately, for something to happen to you and leave them behind. And not only could something happen while you're at work, you could be at home while they're at school, or of course, a lot of our time is spent taking care of the kids. And there's a lot of things that both mothers and fathers are doing every day. Now, a typical estate planning workshop that I give many times throughout the year would focus a lot more attention on how to save money in your estate planning, avoiding taxes. Maybe we're more concerned about long-term care or retirement planning. But the focus of this workshop is really going to remain on parents of young children and what you can do to be prepared for the worst of situations, or maybe even the best of situations, to help put you and your family in the best scenario. So I find there's really some 5 big mistakes that we find that young parents make. And one is let the courts decide who's going to raise their child. If you don't choose before it's too late, your vote won't get counted. So having some sort of plan for if something happened to you, who would help raise your child is obviously number one. A lot of people think, well, it's just not necessary. If something happens to me, my spouse will have no problems, or my parents should be able to take over, or my siblings, or whoever it is that you're planning on. And again, the default rules may not be what you think they are in those cases. A lot of people at our age, I find, a lot of peers of mine in their 20s, 30s, and 40s, when their kids are just being born, or maybe as they're growing up, just are not preparing for something catastrophic to happen. They think there's just not a very high percentage of something bad happening to me. I'm kind of still invincible at this point. We find most people really attack estate planning and putting wills and trusts and things like that together when they see their own parents maybe going through some of the problems and the good things and the bad things that they've done, or they have a health scare or something happen that makes it a reality that maybe something bad will happen. So that leaves many clients totally unprepared to not only worry about who's going to raise our children, but what kind of care should they receive, and what kind of education is important for them, or what special health concerns might they already have, or might they have in the future, that we really need to make sure our guardians are prepared for. And it's a really tough decision of how do you choose that person. And there are some times when you have just the perfect person that if something stepped in, now, of course, nothing would be as good as you are. But if something did happen to you, sometimes there's a great option, and sometimes there's just a better option than everyone else that might show up to try to take that role, or that might get chosen for you. So we're going to talk about all of that stuff today. And again, I hope that you take some good, not only knowledge from this presentation, but some action items is really what my goal is whether you do a full official plan and really start doing something, which I really strongly encourage, whether with our firm or any firm that specializes in this, that would be perfect and best case scenario. But also there might be some things that you can do just today, right after we get out of here, that might say, you know what, I should do that. And I wonder why I haven't, and kind of get something started for you. As I said, I'll talk to friends, and most of my friends, thankfully, with young children that we hang out on a routine basis, know that I do this kind of stuff and have actually taken the step of putting together a plan. But the vast majority of people um, with young families, specifically a recent survey, people under 35 said, weight's a bigger issue than estate planning, or they'd rather get a root canal than do their will or their trust, and it's not fun stuff to think about, possible death or disability. And so I recognize that. Another thing that young couples say oftentimes is it's just not necessary. Again, my spouse can take over anyway, so what's the point? Or it's in the unlikely event that could happen, somebody can just pop in. And again, the default rules are not as easy as you think they would be, and they are probably not what you would want to have happen. Now, the fact that people sometimes say, it's so unlikely for young people to die or become in a bad accident. I mean, we obviously see it on the news every day, or we'll see a Facebook GoFundMe page or something pop up where a tragic accident happens, or a severe illness takes over on a young parent who maybe recently had a child or still has young children. But that possibility might seem really remote to you. And yet there are a lot of things that are far less important than your children, than your spouse, than everything you've worked for your entire life, that we spend a lot of money on every single year in the unlikely event that something happens. So, take for instance, how many people on this call have had their house burned down? A lot of times the answer is no one. And I hope that's the case, because it is awful when that does take place. And yet I bet everyone on this call and everyone listening pays for homeowners insurance, which, could be thousands of dollars a year, to ensure the case that might happen one day. And yet, again, a lot of times I'll see people spend $0 on protecting their children and their future, or Google, cheapest will in St. Louis, and print out a online document that came with a Groupon for $29.99 or whatever, and put somebody's name in that spot that says legal guardian, and think, well, that's good enough. I think I've done it. Thank goodness I got in front of this. And again, I think that's just not the best plan for my family. I know that, and I hope you'll find it's not probably the best plan for yours, and there are more steps that you can take. So let's do some looking into, what would happen if you didn't have a plan in place. And I sometimes will give a presentation on this where I talk about, maybe we have a date night, or my wife and I are going to go to a wedding in Mexico, and the kids are staying home with grandparents at that point. And we're going to compare what happens if we don't have any plan in place versus what we have in place, and what you could have in place that says, this is who I would choose to step in. This is what I would want to have happen. Your true legacy and your most precious treasure is the protection of your minor children. I think for a lot of us as parents, there's nothing even close to as important as our kids. Maybe a small portion of the reason you go to work every day is so that you can go on these occasional vacations or buy a nice car. But I think most of us, a big primary reason to go to work every day is to take care of our children and to give them maybe a better start than we had, give them opportunities that we didn't have. So let's not lose focus of that. because we want to show you how to protect your children, even if you're not around to do it. I know no one will be as good a parent as you can be. No plan will be as good as you living a long, healthy life and watching your children grow up and get married and have children of their own and get to fill in the grandparent role and all these great things. But we want to be prepared just in case something doesn't happen. So just so you know a little bit more about Amen Gantner and Capriano, we are estate planning and elder law attorneys. We exclusively work in this space. Our office is off in Sunset Hills off 44 near Limburg and Watson area. And this is all we do is estate planning. And myself, I'm licensed in Missouri and Illinois. I went to St. Louis University for undergrad, went to the University of Missouri and got my MBA and my law degree. I am the president-elect for the Missouri chapter of the National Academy of Elder Law Attorneys, and I'm on the board of governors for the National Academy, American Academy of Estate Planning Attorneys, on the National Board of Governors. But more importantly, I'm a husband and father, and these are my kids. And, the reason I did my planning, my oldest is Audrey. On the picture on the left, she's got the bow in her hair. She's 7. Olivia on the left is 5, and then little Lewis there is 3. And, when we went through this process, and I'm sure a lot of you, there might be one person out of the couple that really focuses on these types of issues, and one person that would just as soon not think about it. Maybe you both just as soon not think about it. Well, my wife is one of them that would just as soon not think about it and probably wouldn't have prioritized this stuff, even though her children by far are the most important thing. She just doesn't want to think all day, every day about money and tragedies and issues happening. And so I know that I had to do a lot of proactive planning in terms of keeping records of what stuff that we have, what are our logins, what investments are where, and what's our saving strategy in our budget, but then also make sure our legal documents are up to date, our powers of attorney in case we get bopped on the head or put on a ventilator, which we've all seen can happen in a hurry in these last year and a half. And of course, we need to get our wills together and name guardians. And then a lot of times we'll see, again, in other presentations, I talk a lot more about the estate planning portion of how you leave the money, where can I just avoid probate by leaving money, my life insurance beneficiary to be my spouse and then equally to my 3 kids? Well, as cute as those 3 kids are and as smart as they are, how many people by show of hands think that 3 years old is the right age to receive a lump sum of money? Or how about 5 or 7? Of course not. If something happened to us, we cannot send a lump sum of money to minor children. And in reality, the court would not allow that. Even if I passed away and I named as a beneficiary my kids for whatever reason, not my wife, if they were the beneficiary of a life insurance company, even my wife as their legal guardian and parent would have to get a conservatorship where the court would be in charge until they turned 18. And then when they turned 18, they would get it. And I know 3, 5, and 7 is not the right age to receive a lump sum of money. And in my experience, very oftentimes 18 is not the right age to come into a lump sum of money either. So there's a lot of great planning that we've put together about not only who would be in charge, but how could they get the money, for what reasons could they use it, and when and how. And then we'll talk a little bit about this guardianship journal, which we can write down things like who their doctors are and what medications are they on, and what schools do they go to, what schools do we want them to go to in the future, what churches do we practice in, and where would we want them to go, and all sorts of stuff that is far beyond putting someone's name on a 5-page simple will we print off the internet. And so again, I really encourage you to make it as important as it is, because to me, there's nothing more important in my life before, during, or in the future that I can see than the care of my family. And it's worth putting a little bit of thought in. And again, you guys are all the one percenters that are following up on education and making sure you're doing the best thing for your family. So what are some things that young families are typically concerned about? Hopefully, the reality that sometimes unexpected tragic events happen. We've seen in our office people in their 20s and 30s that die suddenly, whether it be car accidents or unanticipated heart attack or aneurysm or something like that. We've seen young parents that you get breast cancer diagnosis or other things that come on more aggressively than they hope. Again, most people will at least understand the reason to do estate planning oftentimes centers around coming up with a guardianship plan for your kid or kids. Now, the exciting thing about estate planning when you're young is we still have a lot of earning years in us, hopefully, and we can do all sorts of long-term tax, financial planning. We can talk about lifetime gift strategies. Should we be putting money in IRAs or taxable accounts or Roth IRAs? Should we be investing in Bitcoin or that, or whatever the case may be? And we can look at, again, maybe we could provide a lifetime of income for our children, and then there still be money left for our grandchildren. And at this point in our lives and with decades ahead of us, there's so many options about exciting things that we could do to make your legacy far more than, let me put this name in the blank for who's going to raise them, and then let me put all the money that I've saved in some account that the court can be in charge of till they're 18, and then they can get it. So ensuring financial security for your kids and loved ones is a primary goal I think we should focus on. So why don't people take care of these things? And there's two major reasons that I see for young families and really for people of all ages when it comes to estate planning. One is it's on the list of things to do. I come from a large family. I'm the second of 7 children. My mom was the oldest of 6. My dad was the oldest of 7. And, I have a lot of aunts, uncles, cousins that pre-COVID anyway, at Christmas and Easter or whatever the holiday may be, I'd see the big group. And, when I started doing this 13 years ago, I had people come up and say, "Hey, you're doing estate planning? That's great. I need to do my will. I need to do my will, or I need to update my will." And I say, "Great, hey, here's where my office is. Just call me. You get the family discount and everything. Just give us a call, and we'll set something up." And there's still a good portion. Many of those people, to their credit, have done their planning since then, but there's still a good portion of them that I'm sure when we see them, when things open up again, they're going to come back to me and say, I realized I still haven't come see you. It's on my list of things to do right after, join the gym, right? Or start the diet. It's on the list of things to do. So please don't procrastinate. Unfortunately, many times we are not given a warning when it will be too late. Now, the second reason, which is far more understandable and kind of excusable in some ways, is you don't know what you don't know. We don't even know where to start. What does estate planning mean? Most of us think it means I got to get a will. But as we'll talk about a little bit today, and certainly if you wind up meeting with somebody to discuss your personal situation, you might find the will is not even the cornerstone document that you're going to want to work with on an estate plan. But you wouldn't know that because we just know what we've heard in passing, or maybe what your grandparents talked about, or your parents talked about with your grandparents, or what you saw on TV. And it's very hard to keep up with tax strategies and life changes and law changes. I'm sure if you're like me and you watch the news or read way too many news articles, you see that we don't even know what the tax laws are going to really be next year. And there's been a whole range of things discussed over the course of the last year. And it's very hard to keep up with what's reality and what's just a Facebook meme or an article from a very biased source that doesn't even really tell us the real story. But even after today, when we talk about real cases and real situations of what you can do and what planning does versus not planning, knowledge isn't enough. Again, let's just use the exercise thing that everybody always uses. We know how to get in better shape, right? Move more, eat less, basically. And yet knowing that hasn't made me lose any weight since we've been sitting here. We got to put the real focus is getting into action. And so again, it's the number one thing. So What I want to cover today, we want to talk about estate planning for a new generation. We want to talk about protecting your children if you're not around, how a serious accident or illness could impact you and your family. What happens, of course, if you pass away. Give a few tips about how to pick a guardian if that's the thing holding you back. I can tell you, when I started again doing this, I looked to my family and my own parents, and I said, um, let's update your estate planning documents. Let's get your will looked at. Let's see if a trust makes more sense. And my parents said, Paul, we're embarrassed to tell you, um, we don't have anything yet. And as I told you, I'm the second of 7 kids. And I said, you raised 7 children and you didn't even do a will to say who would raise us if something happened to you. And they said, no, that's the problem, is we had 7 kids and we didn't want to split our kids up. And there's not many people that you can say, hey, if anything happens to us, can you raise an extra 7 kids at your house? So I get it. There's always reasons. And the reality, though, is by not making some tough decisions, even if not perfect decisions, the only thing my parents had assured to that point was that they weren't going to have a say in what happened to their 7 kids if something happened to them. Now, thankfully, they made it to 2009 when I talked to them, and we got all their planning together and put together a great trust-based plan and wills and powers of attorney and all that sort of thing. I said, at this point, most of us are grown. I still had 2 younger siblings that were high school age, but I said, we can name the older siblings as their guardians at that point, kind of a party of 5 situation or something. And so they did. And for the first time, my parents, who were married for almost 30 years at that time, almost 40 years at that time, we're talking about their finances and what they would want to have happen, and thinking about the bigger picture. And a lot of times in a marriage, this parent takes care of this parent takes care of that, and they don't even, talk about some of the other things. Well, only 5 years after that, my dad at 61 went to bed on a Thursday night and did not wake up Friday. And he was not sick. He didn't have a particular illness. I woke up to a phone call from my mom, hysterically crying, saying, Paul, I think Dad's dead. What do I do? I said, what? She said, I think Dad's dead. He's cold. He's not moving. What do I do? I said, did you call 911? And she said, no, should I? I said, yeah, call 911. And I rushed over there, and 10 minutes later, the paramedics were already walking back to the ambulance. And, I said, I guess there's nothing you could do. And they said, no, I'm sorry. And I walked into the house, and my mom had just lost her spouse of almost 40 years, and much sooner than any of us anticipated. And, she pulls out the big book and all the documents we did and says, I know it was a good thing we did this, but I got to be honest with you, I don't have any idea what any of this stuff means. I've never filed a tax return in my life. I don't know. She got married at 19, moved from my grandparents' house to in with my dad. And again, just never kind of handled that portion of it. I don't know what bills are coming out of where. I don't know how to notify his work that he's not coming in, much less, what to do about, tax planning or financial planning. And, Paul, I just need you to take care of it. And it really became important to me at that point that, we recognize that estate planning is not just drafting documents and signing it. It's having a plan for what if you didn't wake up? What if you didn't come home? And go from there. So we want to personalize, whatever solutions you have to your needs, and whatever solutions can be offered to guarantee your spouse's future and your children's future. So I also want to tell you, one of the things that I, offer when I come to do this fall scheduling and workshop series is, I would not charge anything for an initial consultation. At the end of this, I'll kind of give you an idea of costs and things like that we use. Of course, every law firm might be different, every other option is different, but I can tell you what and what they offer is different. Again, a will is not a will is not a will, a trust is not a trust is not a trust. It's a scope of planning, but I would be happy to have any participant on this call, if you mention that this is where you heard about us, when you call into our office, which I'll share that information. I wouldn't charge for a free 60 to 90-minute consultation to talk about what you could do. So here's a question: what would happen to you, to your children, if something happened to you catastrophically? As I mentioned, we do occasionally with young kids get to have that special date night. And I know, and if you're a grandparent and not a parent on this call, or if you're a parent, I know that you don't leave for the evening without saying things like, don't forget they have to brush their teeth. Julie can't watch videos past 8 p.m. If anything happens, this is the neighbor's phone number. Don't give Billy peanuts, he's allergic. This is the book that they read. This is how you work the TV remote. These are things they can eat. These are things we don't want them to eat. This is where we are. After that, we're going to be here. This is the emergency number. And yet we do that every time we go out for a date night, for a 2-hour babysitting session with our with our parents, their grandparents who watch them all the time. And yet many people don't give much thought to, what if I don't come home at the end of this? And what do I need to think about beyond tonight and this 2 hours? And again, I get it. It's not fun to think about, but today we're going to think about it. What could possibly go wrong? You could get in a car accident and be okay, relatively, not pass away, but you might be in the hospital for a few hours, and that person doesn't know what happened to you and get a call from the police, or you could maybe not come home. And again, those things both have ways we can prepare for them better than doing nothing and hoping it doesn't happen. And again, I want to make sure that we talk about not only what if you're seriously injured and are going to be in the hospital for an unknown amount of time, but what if you won't be coming home at all? And a lot of people are probably saying, listen, my parents would do whatever they got to do to step in. Or I've talked to my older sister, and she and her husband will definitely take care of our kids if something happens. Well, unfortunately, without some sort of legal directives and instructions, the court's going to be in charge to make sure the people that are going to take care of your children have the authority to, whether they're appropriate to. And it's all going to be without your instruction if you haven't prepared anything. And there are a lot of things that you can do to make sure that what you want to have happen will happen, and that it is going to be very smooth and easy, at least as smooth and easy as it can be in such a tough situation, as opposed to a protracted legal battle between your in-laws and your parents. So how do we choose who a suitable guardian might be? What does that exactly mean? What is the court looking for? What types of things might you want to do? Well, first of all, we want to think about two different types of guardianship. If there's an emergency situation, one thing you could do is do something that you sign while you're alive and okay and able to do, a directive by your parents. And you can do this temporarily. You can say, for instance, when I'm out of town in Mexico and I'm concerned what if my kids need to go to the doctor for that week, and my mom or my in-laws need to take them to the doctor's office, I need to give them the authority to do that. And so there's temporary directives that you can assign. Now, anything that's more permanent than that, if you wind up just not coming home, you're going to need a court-approved order to nominate a legal guardian. But the number one person that they will choose is a person that's elected by their parents. And again, typically a will is where you would elect the name, but we need to have some more strong instruction from that. So what if you're not coming back? Long-term permanent guardianship can be very rigorous, complex, and lengthy. Again, this is oftentimes the forum where you're going to see families battle each other for custody. And this is in good marriages where both parents, loved each other and everything was fine versus, God forbid, what if you're in a divorced family or blended family situation or a single parent, or how much do we want the court to be involved in sorting out the family mess? And it's not a position we would want to put our kids. And it's not something we would want to have not discussed with our spouse if we found ourselves in that scenario. So what are some solutions to having that protracted legal battle? One of the first things I would do is nominate a guardian. Again, this is something that you have to choose by definition before it's too late. So nominate somebody that if something happens to you, who you would want. And if they can't do it, then who? And if they can't do it, then who? And you'd want to have both parents on the same page. You don't want to have conflicting lists of who that person would be, but nominate that order so that we know that that would be the choice of who it would be. Now, what makes a good guardian? I kind of led into this, but now I'm going to start going over some things that you might think about when choosing a legal guardian. What about how much money they have? Is that the most important thing you think? It could be something. It doesn't hurt, I guess, if they have more resources, maybe they'll be able to and will pay out of their own money for more, for better medical care, or for, for schools, better schools. But for most of us, I think it's kind of our job to have the money part figured out for whatever the guardian is. So in most scenarios, the guardian's not using their own money for the care of their children, of your children. They would be using money that you've left for them, either through life insurance or other planning that would play a role. Now, if you think this person has so little of their own money that they might try to squeeze money off my children's share of the inheritance that I left them, well, there are other reasons that person shouldn't be nominated other than how much money they have. There are plenty of people that might not be super well off on their own that would make great legal guardians given resources by you, the parent, for the benefit of the children. So what things might be important? Parenting philosophies, I know, goes into a lot of it. I have a lot of conversations with young parents that just say, I don't know, I see how they deal with their own kids, and I don't know if that's the way I would want my children to be raised. Maybe it's religious beliefs. It's really important that they have a Catholic upbringing or a Jewish upbringing, or whatever the case may be. What about location and geography? Some people say, well, this person would be great, but they're in Chicago and we live in St. Louis, and would it be bad to uproot them from schools that they're used to and friends that they have? And in addition to, they just lost their parents, now they're going to be moving cities as well. What about discipline styles? Are they, too disciplinarian or not enough? Personal values. Unfortunately, we probably all learned more than we ever wanted to know of our family's personal values and political beliefs and other things in this world of social media. But that might play a role in who you would choose. Personality type, temperament, all those things are good things to consider when you're choosing a guardian. So as I said, speaking of money, isn't it one of the most important things to do to think about, if you passed away, would there be enough money for your child without your future ability to earn it? And in some cases, in many cases, for parents of young children, they haven't had enough opportunity to save up a bunch of money in investments and say, okay, good, I can, quote, self-insure. And if there's anything that happens to me, they have more than enough money from what I've been able to save up. Now, probably at this point, when your kids are young, you're going to need to supplement that with some form of life insurance. Now, it's not always the case, but it might be something to consider. It's not that expensive. If you're a healthy 35-year-old woman, non-smoker, it might be $31 a month for $1 million policy. A man, same age, same health situation, might be 35 for a 15-year term policy. A 40-year-old woman might be $42 a month. Now that's a 15-year term, which means at the end of that 15 years, bad news is you spent $31 a month for the last 15 years. Good news is you didn't die. And this type of insurance is not to build wealth, it's to protect for dependents who are dependent on you. And by the time maybe you're 50 or 55, think about, okay, by that time my child will be, maybe 20 years old or 25 years old. And at that point, they wouldn't be financially dependent on me anymore. So that's an idea to think about. Obviously, if you go to a 20-year term or a 30-year term, all those prices will change and those costs would change, but it's just something to maybe keep in mind. The other thing to think about is what's the relationship that the guardian currently has with your children. Think of how much more of a shakeup it would be for your children to all of a sudden be in the care of somebody that they didn't really know prior to this happening, versus somebody that they might already have a great relationship with. Maybe they do a lot of babysitting already, or visit each other, and maybe if it's a sibling of yours, maybe some of their cousins are about the same age. And there's a lot of things that you can play into that decision. Some important questions: how many children do they have? Do they plan on having more? Are their children older or younger? If your kids are 2, 4, and 6, and your chosen guardian has children that are 18, 20, and 22, you might want to have a conversation with them of, would they be up to the task to kind of going back and starting again with a lot of young children in the house and all of that. And a lot of people, when they first have their first baby and first child, that are very forward thinking and do their planning, look around and they might say, okay, I'm 30 years old and my parents are 55 and 58. They could easily do it. They're still very vibrant. And we went to Disney last year and they were walking around everywhere we walked. Well, by the time your child, if this is the only child you have, is 18, it might be a different question. It'd be 73 and 75 or whatever ages that would be. So you got to think about, would they be able to have the time and energy in the long run for that to happen? Are they physically and emotionally able to care for your children? Again, there's no age where you're automatically not capable, but obviously the ages, might mean knee replacements, or it's harder to walk, it's harder to do some of those things. So something to consider. Again, what kind of parenting values do you picture the kids having and in their future, and what matches most closely with what your values are? Again, there's not a right or wrong way. It's very personal to you.
We've got several questions that have
Great.
just come in.
Great.
So the first one is, what's the best way to designate a percentage of the overall inheritance for the caregiver so that they get a portion and then the remainder will be split amongst the 2 children when they are old enough to inherit it? Is there a percentage that is typical for a caregiver?
I assume we mean caregiver being like a nominated guardian, like your sibling or your friend or whoever the case may be. And if that's the case, I would say there's not a typical percentage. And in many cases, the answer is not. You could, if you did a trust or something along those lines and they were also the trustee, we oftentimes would have built in that they would be able to receive reasonable compensation for their efforts. As far as the kids, I know when and how they get the money. There's no perfect way. I know one of the most common ways when I talk to parents of young children is I want some third party to be in charge for the benefit of these people that I care about, being young kids. And I want them to use it in a typical legal standard is for their health, education, maintenance, and support. And that health and education seem pretty clean and clear cut, hopefully. Maintenance and support means, and I want them to continue to live in the standard of living that they would have lived in if we were still living. So even if you have $1 million life insurance policy and you didn't used to have $1 million, it doesn't mean woohoo, happy birthday money for your kids. Now your caregiver gets to buy an Escalade and show up to class, in the best and the brightest. It should be just maintain their standard of living. And then when they hit certain points, the money would become theirs. And again, a typical way would be maybe they get a portion at 25, a portion at 30, a portion at 35. I've seen people do other age brackets, but that's a typical way to look at it. And again, there's unfortunately not a perfect number for that. I've also talked to people that say, hey, I don't want to deal with doing a trust and whatever else. Couldn't I just leave my life insurance to my mom and then have my mom be the guardian and then she'll take care of them? You could. That's kind of a back alley way to do it because your mom has no legal responsibility to use that money for your kids or to even accept the guardianship. So that's a real dangerous way to leave money, like where you do the unofficial, I'm just going to leave it to my brother and he'll take care of my kids. So I don't recommend that. I hope that at least gives some thought.
The next one is, what are my options if I have no reliable backup to take my kids if I die?
Again, sometimes there's not a perfect person. I would think about really deep about who the best person that you could possibly choose would be. There are public guardians and there are foster families and things that take care of people where there is no nominated guardian and there's no one that steps forward to take care of our children. Again, that's not taking your vote into consideration at all. So even if you don't have like, oh, my brother would be good, but he drinks too much. My sister would be good, but she doesn't have a good job. Maybe it's your friend, your best friend who you talk to all the time, and it's a serious conversation that you have. Maybe my parents would be good, but they're just a little too old. Well, the age thing, if that's the only thing, that's better to have than not a nomination at all. So that'd be one thing there's no magic answer for anybody. I would typically choose somebody with the closest, best relationship with your children, and that most closely meets that profile of things that I just went through. And that's better than foster families, in my opinion, or the courts choosing. Again, not that there isn't a great place for both courts and foster families. It's just might as well use your powers now.
Thank you.
Mm-hmm.
Can backup caregivers just add my children to their medical insurance if they become the legal guardians?
Yes, if they are typically. I can't imagine an insurance policy that wouldn't allow a legal dependent to be added. Of course, it depends on the plan as far as, is that included? Would your employer pay a portion of that, or do you just have to pay for it? And how much is it per dependent or whatever else? But typically the standard for adding someone to your health insurance is a dependent under the age of 26. And that could include legal guardian as long as that fits the bill.
All right. And will the legal guardian have to adopt my children? What is typical?
They do not. And in most cases don't. I don't know that there would necessarily be a reason to do adoption in that case. Adoption we typically see in step parent families. And one of the effects of legal adoption is cutting off inheritance rights of the natural parent, and the adoptive parent then becomes the person they would inherit from. So if both of your parents were deceased and you kind of inherited from them, you might inherit from your grandparents who later pass away on that side. But if your friend took over as guardian, it would be rare that they would then legally adopt you and make you a child on that side, as opposed to legal guardian.
And now we have just one more,
Okay.
and that is in the case that you mentioned with my brother would be good, but he drinks too much. Can that be a concern you document in your estate planning document somehow, that it is a pre-existing issue that you are concerned about, yet he is still the best and only option?
It is, and actually, I've I have that situation on a client situation where, um, and what I've asked is, for them to not only have that documented, what their concerns are as the natural parent, but to maybe even do it in your own handwriting, of a letter signed and dated by you of your concerns and what your thoughts are, because unfortunately, nominating in documents for legal guardianship, it's not going to avoid completely the involvement of a court, because we still need a court to eventually order the guardianship, and they'll still have a guardian's report that would be due and everything until they're age 18. Now, again, the money doesn't have to be with the court, which is usually the expensive part. I would usually set up some sort of trust arrangement, either through your will or through a revocable living trust, but so that's outside of the court's purview. But the care of the child would absolutely still be in that purview. So if you have a handwritten letter from parent saying, I nominate this person, but these are my concerns, then that would be something that I would have submitted to the court, so that they can take into account that this is still their nomination. They are aware of this, and it's possible the court could even ask for a test, routine tests or some sort of check to make sure that that's not a problem. And at least they'll have an annual guardianship report that they have to file with the court. So yeah, as far as school districts, again, sometimes that's important. I know a lot of us probably, when we moved into our current house before we had kids, or maybe we're hoping we get out of our starter house and get to buy a new house in a different school district when our kids hit the school age or hit middle school. But when you choose a guardian, their residence will probably be their house, unless there's some provisions and ability for them to move into your house and use that, which I've seen people do and allow as well. Again, you'll want to have those discussions with whoever would be the guardian, because they might not be willing to uproot their lives that to that extent. So think about where their house is and what schools they'd be going to, if you're going to do certainly a public school system as well. If there's someone you don't want on the guardian list, have that too. Again, maybe that person that we're concerned about, but still they're the best person, is different than, I am so concerned about this person, I don't want under any circumstances this person to become the legal guardian. Then of course we wouldn't nominate them on any documents, but we also might want to document your strong disfavor for that decision by the courts, because again, that will be highly weighted by the court when they appoint a legal guardian. And so, as we were talking about, make sure your guardian documents alert the judge about your concerns, for better, for worse, whether it's a deal killer or just something you're concerned about. That those were great thoughts and great questions about choosing a guardian. Typically there are about three different types of guardians that I deal with pretty routinely. The permanent guardian is the one that we're talking about, nomination in your will, has the legal right to take permanent custody of that child and care of that child. And they don't have to be in close proximity. And they would be able to have all the authority of future decisions. And it could be someone that you would choose on an emergency basis, but not necessarily. An emergency healthcare guardian, which could be the same person, I'm sorry, as your permanent guardian, but doesn't have to be, could be someone that has the legal authority to make healthcare decisions while you're gone, including an emergency medical authorization form. Again, even if it's only temporary, that's something that you can document in writing and authorize, and the doctor's offices will recognize. And then in some cases, we do adult guardianships. when a child turns 18 and still may need the care of someone else to take care of their needs. And so that would be an adult guardianship. And you're typically going to have to go through another process as the minor child reaches the age of 18 if we're going to continue that legal guardian status beyond the age of 18. Because in the court's age, or in the court's mind, by default, when someone turns 18, the parent or legal guardian no longer has authority to make decisions on behalf of that child. And as I'm sure we've seen a lot of times, a typical 18-year-old without any special needs might have problems making their own adult decisions at age 18, but certainly there are many cases where an adult guardian would be appropriate. And if we know that when your child is age 8, that it's likely that an adult guardian would be required, we can kind of plan for that as well. Or if your child is, you're a legal guardian for your child who's now 22, but if something happens to you, we need to nominate a successor guardian for your adult child, we can do that as well. So, and that's something you'll want to document, because again, that's going to be the first thing the court's going to want to see. So what's next? Important. We want to summarize what we talked about: the importance of choosing a guardian, vital factors to consider, the different types of guardians, and emphasize the need of legal documents to give the guardian authority to act. Again, it's not something that just by default your parents are authorized for or your siblings are authorized for. It's something you need to put in writing and make sure you do it. So obviously, different generations have different needs, have different solutions. I'm going to talk about a couple of options of how you can address your needs and your concerns. Again, not knowing anything about any of your specific goals or your specific concerns. We have kind of two main categories when it comes to estate planning for young families. One is kind of your more basic estate planning, where you do, all right, I need a will because I need to prevent the state from making decisions for you. I need to nominate a guardian. The problem with your will being the cornerstone document for your estate planning is that puts the probate court in charge. So when people come up to me at the family party and say, hey, I need to do my estate planning, I need to do my will, I need to update my will. And then they say, I want to avoid probate. And maybe they don't even know why they want to avoid probate, but it's costly, it's public, it's time consuming are some of the reasons. But what they don't realize is a will doesn't avoid probate, a will directs probate. So actually the only place in the world that a will matters is in probate court. So you can't just take your will to Merrill Lynch or Edward Jones or US Bank or wherever and say, see, my dad did a will and he named me executor, and I understand he has accounts here. Here's his will. It shows that I'm the executor and maybe I'm even the sole beneficiary. I'd like access to that account. They'd say, great, we just need you to get letters testamentary. And they tell you that like you're picking up a dozen eggs at the grocery store, but unfortunately, that means they need you to open a probate estate, and the court will then be in charge. Other issues is unless your will sets up a trust within it, then we're going to have that scenario where it's outright distributions to whoever you name as the beneficiary. And whether it's minor children, when we for sure don't want them to get outright distributions, where the court would be in charge of everything, whether we buy new diapers or attend that summer camp or join cheerleading this year or not, the court would have to approve every one of those expenses if it's through the probate court. And then when they're 18, they get a lump sum payout that they may or may not do a smart thing with. I just had a meeting earlier this week with an 18-year-old whose grandfather left him some money, and not in a great way. And unfortunately, the father who was the son of the grandfather, had to apply for a conservatorship over that money until his child reached age 18. And now the dad's sitting here like, my son is 18 and he's a smart kid, but he's 18. And I don't know what he's going to do with $300,000 or whatever the amount of money is, but I'm worried it's not going to really change his life. It's just going to be woohoo, happy birthday money. He's going to be the most famous or, most popular senior in high school. and then it's going to be gone and it'll be as though he never got anything. I really wish he would invest the money for the next 20 or 30 or 40 years and retire early, unlike I'm not going to be able to, or whatever the case may be. Um, so you're not going to have all those options if you do your more basic planning, but that's one option that you can go through. So then people talk about, well, what is a trust? I don't get this. It seems like a trust is just for those people with millions of dollars that, the trust fund babies, and it's not really like that anymore. A trust has become far more typical. And the way I like to describe a trust is it's a way for you to set up like a tube of toothpaste, all the assets that you want this person to get, and they're the toothbrush. And you can put somebody who you choose their hands on the tube of toothpaste, and you can squeeze it out for the reasons that you want or over the paste that you want onto their tube of toothbrush or onto their toothbrush. And then everything that stays in the tube is protected in case they get sued, in case they get divorced, in case they're on government benefits, whatever your concerns might, in case they're just going to spend it all. You can offer a lot more protection that way through a trust. So you can tailor those specific rules however you want, depending on your particular toothbrush. So I like a trust a lot better for my own family. But a will is going to be where I still have a will. I have a trust and I have a will. My will is just a pour over will that says my only beneficiary of my will is my trust if something wasn't funded during my lifetime. But I have my guardians nominated through the will, and then I have this separate guardianship journal with the more detailed instructions, which I'll talk more about in a second.
So once our planning documents would be in place, how do you suggest we start talking to our children about this? At what age is appropriate for the if mom and dad die, this will happen discussion? I just don't want it to be a surprise for them.
Right. I think that's a really, personal choice, obviously, and a thoughtful thing for you to even be considering and thinking about. I haven't with my 7, 5, and 3-year-old mentioned that. I feel really good about not only our first choice, the first person listed. I guess I shouldn't say first choice because we trust and love everybody that we have on the list. But I honestly, the second or third name on there, we revisit every year. We make sure it's still the right answer, but we haven't gotten to the point where we've included them in that. And as a parent of only 3, 5, and 7-year-olds, I think each kid is different as far as how much emotionally and even intellectually we can understand about that. I would probably wait a little bit longer, but I don't know. Maybe your kids are really bright, 7-year-old or whatever. Otherwise, maybe teenage years or when they get some sort of understanding of that. That's so tough. What a good question. I've never had that question before, but I mean, my 7-year-old and even my 5-year-old understands dying and talks about they never met my dad. Unfortunately, he died a week before my oldest was born. And so that's one of the things I really feel bad about, but they talk about grandpa being up in heaven and all those sorts of things. So when they start having those kind of thoughts, they at least kind of understand that death is a part of life, but I don't know. Sorry.
Yeah, that is a tough one.
Hmm.
Can you have a trust with no money in it?
Sure. You can. What I typically, if you were going to do that, we could do like a testamentary trust. Through a will, say create a trust at my death. If you're not going to fund it during your lifetime, you could have a trust. I'm using visuals here just because I'm a more visual person, but like a tube of toothpaste, you could say it's like a box, and you're setting a set of rules. And when we talk about funding the trust, that means how does the money and the assets get into the trust? Now, some things we want to fund during your lifetime. Like a lot of times, like my house, I put that in the trust just for privacy concerns, but also for tax purposes. There's some reasons why you may or may not want to do that. But there are other assets like life insurance. If I have a term life policy and I make the beneficiary a trust, it's not going to get there until or unless I die during that term, because there's no cash value. There's no owner that I could make the trust. Your IRAs, there's all sorts of tax reasons why the plan participant has to own it during your lifetime, and why, if you're married, you probably want to name your spouse as the primary beneficiary. So the funding of the trust wouldn't happen until the death of the second of you. That is certainly an option as well. And a revocable living trust, it's not like there's any separate tax forms you have to file or any ongoing costs or administration. So it's not like having the box, but not having a lot to go into it would be a lot of ongoing expense or complication if there's not anything to fund right now.
All right. Your final question is, can you set up a trust for yourself to protect yourself from your own bad decisions?
You could. Yeah. I mean, again, part of the problem that I have sometimes is when we're trying to plan after something has happened, our options are a little bit limited. So in the case of disability planning, a lot of times, like, special needs trusts, if we left money to someone who is on government benefits and it's outright, they're already named beneficiary, and that person passed away, the person passed away that left the money, then we might be stuck doing a first party trust. And there's a lot less good options, a lot more restrictions on that. If we left money to an 18-year-old and then we said, whoops, this person's going to do a bad thing, or grandpa left it to the 18-year-old, like that conversation I had earlier this week, I said, well, Dad, unfortunately, now that he's 18, you can't do this for him. He needs to set this up himself. Now, if we set up a trust that says you have this limited access, but you're the trustee, think about, again, your 3-year-old with the tube of toothpaste and tell him to squeeze just a little bit onto the toothbrush. Sometimes it all just comes pouring out anyway. And there's not a lot of checks and balances. So I would use a third party if I were going to say, I don't trust that I'm not going to spend it all. So I'm going to name this person and I'm going to set these rules. And you're going to have to be involved in that effort of self-limitation. But funny scenario, good question. And it's not as funny as it sounds. I get it. So a good estate plan can protect your family. I have some people that want to provide financial incentives. So maybe it's that they're not bad people or whatever. You just don't want to change their lives. What if I leave so much money, my kids will never work? Or it's not that much money, but they'll think it's so much money that they don't have to work. You could say, I only want my kids to have a matching distribution from the trust of whatever they can turn into the trustee on W-2s for the year. So at least they could say, you got to get a job too, and you got to work. And if you do, we'll pay this. And we could double your money or triple, there's no matter. You could say they get 5 times whatever they earn. I have some clients who want to help their grandkids out, and they're trying to encourage them to contribute to a Roth while they're young, because they're like, I wish they had Roths when I was young. And so, but a lot of times young people that just started working don't feel like they have an extra $6,000 to fund their Roth with. So they said, tell you what, if you can put $500 in there, I'll give you $1,000. If you can put $1,000 in there, I'll give you $2,000. Where it's kind of like incentivizing different things. And we talked about maybe drug or alcohol problems. You could have in there, this person only gets a distribution when they can give a clean test, whatever that case may be. So, and again, sometimes there are 45-year-olds or 65-year-olds who would blow through the money. And the unfortunate reality is inherited money oftentimes feels like woohoo, happy birthday money. It doesn't feel the same as the money we work for our paychecks and save up and skimp away for a rainy day. Whether it's $20,000 or $200,000 or $2 million, it feels like just found money. So, you'll want to take some steps to protecting it if you can. And of course, unanticipated things happen. 50% or close to 50% of marriages end in divorce. And I don't know anybody that would say, oh, I hope, I'm going to leave this money to my granddaughter, but if she gets divorced, I want half the money to go to her ex-husband and his new family. having all those protections, protecting from potential creditors. Again, somebody else I met with this week was in the middle of a divorce, and his mom, I mean, one was in the middle of a divorce. Another client that I meant to be talking about was in the middle of a bankruptcy, and mom's health was going down quickly, and mom realized that, and so she quickly changed her estate plan to have asset protection so that his inheritance will not be included in the bankruptcy, so he can settle all of his debts, get a clean slate, and then once all that clears, he could start getting distributions from the trust rather than just going to pay off creditors. So again, there's all sorts of things you could do depending on what your situation is. And sometimes another question that I get a lot of times is, should I name the same person as the legal guardian of my children as the person that's in charge of the money? And there's no right answer or wrong answer, I think. At least no universal answer, I should say. Depending on your scenario, there's certainly a right or a wrong answer. But I have seen it both ways, where they say, you know what, this person's going to be the legal guardian. They should have access to the money. I'm naming them both because I trust them, that they're not going to go out and say, I need this brand new car and this brand new house to raise my sister's children in, and squander the money. But if you wanted a check and balance, or you say, well, maybe, dad's brother, it could be in charge of the money and kind of set the budget and be the one the kids, kind of have to go through for the money, as well as the guardian to say, hey, this is the plan for school. And they say, okay. And then the guardian could be mom, sister, or whatever. Every case is different, but it doesn't have to be the same person. Could be the same person, could be a different person. Every family has unique situations. So if you're single, and there is no, let's just use an example of, there's no father listed on the birth certificate, or that's taken responsibility or paid child support or anything else, then for sure, let's make sure there's a plan for if something happens to you. But what if you're divorced? Oftentimes, the divorce decree says, there's shared custody. And if one spouse passes away, the surviving spouse, though divorced, would still be the legal guardian. You can't say, well, I'd rather my mom watch our kid than him, and I'm going to take away the parenting rights. You aren't going to be able to do that, but you probably don't want to send all the money to your ex-spouse for the benefit of your joint child. You could say, let's have, one of my siblings or my friend or whoever be in charge of the money to help, because there are going to be some things that are just other parent responsibilities, and some things that your money should go to help give your child that extra push. And of course, there are blended family situations sometimes. So, we have some clients, for instance, that there might be a big age spread. And let's say dad had two daughters from a previous marriage that are in their 30s, and then he got married again, and has joint child with his new spouse that's 2. How is that going to look? And are we going to, who would be a good, maybe their step sibling or half sibling would be a great guardian. But again, do we want the money to go one way? And then you also might think about, in that case, are we going to need to leave more money to the younger child than the older children? We want to treat all the kids equally. Well, these two are grown. Maybe we've already paid for their grade school, their high school, their growing up money. We need to make sure that we're taking care of youngest child until they reach whatever benchmark. And then maybe at age 23, or when they graduate from college, it'll then split into 3 separate shares. So again, I just, there's so many different things that we could go through. But that's really, why I do what I do, and why our firm does what we do is define what's important to you and make sure that that's included in your plan. Again, I've just found in going through this, I know that we all just think of estate planning as, I need to sign this will before I die, or I need to sign some trust before I die, or whatever. But no, estate planning is about having a plan, having a process. and the documents are just the result of that, and tools that we use in that plan and that process. So a perfect plan should include provisions for your guardians, should include some legal documents like those emergency medical forms or guardian authority forms. It should also include some more instructions for raising your children than, hey, your name is it. You should spend some time capturing your values and things that are important to you, things that you would want your kids to know. I mean, I'm sure we've all seen movies where the kids are growing up and saying, what was mom like, what was dad like. I bet we haven't put much together in the way of capturing any of that. What I do, again, is one of my goals as an attorney that does this stuff is to be the personal attorney on retainer, to say, what do I do about if anything happens, call Paul. Or what I told my wife, Sally, I said, if anything happens to me, call Jackie. Again, in many ways, my law partner, Jackie Capriano, is, more tied into what we'll need to have happen than my wife, even though we've gone through the planning process together and done all those documents. Because unless you do it all day, every day, it's going to be really difficult to carry out. So again, in addition to what we do and how we do our planning, is if you became a client of our firm, included in that is our retainer throughout the at least first year that we go through and do all the stuff. And then if you decide to stay on the retainer, we would discuss what that would look like on an ongoing basis. If you don't stay on the retainer, what would that look like? We would want to do a guardian journal. And again, a lot of times what we do is we'll provide, the kind of the blank journal for you and say, hey, here's all the things you need to think about, and format it for you and kind of customize it for you. And then you go and fill it out. And then when we get together once a year, how's your financial situation? How are your kids doing? What's new with school? What's new with emergency information, healthcare? That's all way easier to talk about if we're up on that once a year, every year, and make you get it out once a year, every year, instead of when we get that call and say, oh my gosh, my brother passed away. I understand he did an estate plan with you. What's new? And I look and I see that person drafted an estate plan once 15 years ago, and we hadn't seen them since then. And that's what most law firms are like. And they say, well, I don't know, 15 years ago, we drafted this document, they signed it, they walked out, no idea what happened after that. That's not going to be as good of a plan for you, as opposed to having, a fully put together binder of information, not only for your legal documents, but a totally separate one for my raising my kids documents, my child's protection plan. And again, young families don't probably have a lot of problems with this, but we don't haul around big binders if we don't have to. I've got a little credit card sized flash drive that's got all of our current information. If we go to the doctor, they sometimes ask, do you have these documents, or God forbid, a hospital surgery or something, but also just upload the current documents on that. So if anything happens to me, I got this flash drive. It should have everything that you need. You can password protect it, whatever you need to do to protect that. And then, so again, what I would typically do, rather than more of a basic plan, is my basic plan would include doing all that child protection stuff, doing emergency medical forms, having a guardian's journal, doing a will with at least a testamentary trust provision in there, and naming personal representatives and guardians, and having a more flexible distribution plan for your assets. Have a power of attorney for yourself and a healthcare power of attorney. Everybody over age 18 should say, hey, if I get put on a ventilator, here's who's going to pay my bills. Here's who's going to make medical decisions. And maybe it's your spouse, but believe it or not, your spouse does not have the default ability to do that. If you have not nominated them, they aren't allowed to just sign your name to things or consent to medical information, even get medical information without your consent. So have all that stuff done, and then have it in a place that can be found and easily tracked and updated. Now, a more comprehensive plan is have all that stuff and then have some sort of trust. A legacy wealth trust is what I call it, where, like I said, in my case, I want to avoid probate. I want to make sure it's all funded and as easy as possible for my kids. I want to have advanced tax planning. I expect to have a bigger estate in the future than I have today, but I want to have a thoughtful distribution plan, and I want to have a separate bucket with separate tubes of toothpaste for my kids. Avoid probate and conservatorships, minimize any taxes, and put together. I have a video that I put together for those as well to explain all those documents, and so. That's what we call kind of the more comprehensive. And the reason I'm kind of differentiating those is because I do want to tell you before the end kind of what the costs of that look like. What's the cost benefit? You know, how much money do I have to have before it makes sense to do the more comprehensive trust-based plan? I can tell you, you just have to have enough money to justify paying a little bit more. Because again, whether it's with us or anybody else, you're going to spend more to get more. I truly think that we do a great job and have very great value for what we provide for each of our levels, but there's no magic dollar amount. Or maybe I don't have the money now, but I will in the future, and I know this is what I have. You know, inflation's going up. We know all these things are going to get expensive in the future, and maybe getting a good base now will help you save money in the future. So what we charge just at our firm is our kind of introduction plan for you know, basic planning for child protection plan with all the stuff that I talked about, having wills, powers of attorney, testamentary trusts built into that, digital stuff, the guardian journal would be $1,995, and again would include our 1 year of free phone calls, emails, the true retainer. It's about 4 or 5 meetings, which I'll go over with you in a second. And then our legacy wealth plan, which is kind of the more comprehensive. Hey, we have some money to protect. I don't want to unload all the money at one time. I think getting a revocable trust is a great decision for my family now and in the future. You know, we charge $4,490 for that more comprehensive plan. And again, I will tell you, these are our plan prices right now. And in January, you know, you may have heard inflation and cost of living has happened, and we will be raising those costs into next year. So some people say, well, you know, I'll call them sometime, and then they call next year and these aren't the prices. They won't be after January 1st, just so you know. That's just what they are now. So remember the 2 obstacles: procrastination and lack of knowledge. Hopefully we've got the lack of knowledge part out. The procrastination part is up to you, whether it's me or anybody else. What I do tell you is you're not going to be able to accomplish and certainly have the years of expertise and ability to ask the right questions by saying, great, let's do this, and let me Google cheapest will in St. Louis and download some forms. You're typically going to get what you pay for in that respect. So again, we do try to make the next step easy. If you did want to meet and discuss your situation with us, again, our office is in Sunset Hills. So if you're in the St. Louis area, it's very easy to get from 270 and 44. It's right there. But we would just have an intake form that when you called to schedule an appointment, we'd set a date, we'd send you a little form that would be 2 or 3 pages about your family and basic information. And then we'd meet and say, all right, here's what questions we have for you. What questions do you have for us? Make sure we answer all those. And at the end of that meeting, we'd say, here's what I would do. Here's what it would cost, and sound good or no, and that's okay. So again, being the visual person I am, we got our workshop webinar. The initial meetings with our firm are going to be with my partner, Jackie Capriano, who like I said, is the best. 60 to 90-minute meetings, kind of discuss your plan and your family's goals and what you want to accomplish. If after that meeting you say, let's work together, within the next couple of weeks, we'd ask you to start gathering your statements, your car titles, your house deed, whatever you have, your IRA statements, whatever the case may be, and then bring that in to meet with one of our estate planning paralegals. That's Rachel. And then from that time, we'll start gathering a funding plan, and I would meet with you on the next meeting, which is the risk assessment and asset alignment meeting, where I'll work out how all the financial assets are going to be funded to your estate plan. So should we change this beneficiary? Should we change this? What if we did the ownership change here? Should I have insurance, or should I have this other stuff? We are insurance licensed and financial licensed, so we can talk to you about any of those things. If you have an advisor you work with, that's great. We work with them to kind of make sure everything's working together as opposed to working against each other. And then we would have the signing ceremony. That's Lauren, our other estate planning paralegal, where we get everything witnessed, signed, notarized, and that's about 90 minutes as well. And then the lifetime communications and updates. So don't let this happen to you, and only put off until tomorrow what you're willing to die having left undone. Think about what legacy you're going to leave your family.
So the first one is, well, they're both related to disabilities. So what happens if my son receives special needs services based on his disability? If I die and he inherits life insurance, etc., how do I protect his services if he and his eligibility for his services?
Great question. And the beauty of it is, if it's an asset or income based benefit that you're receiving, or that your child's receiving, then you leaving that money to them or anybody else is very easy to protect if you set something up before you pass away. You can set up what's called a third party SNT, or special needs or supplemental needs share. It's a specific type of trust share that's meant specifically to avoid what you're talking about. People that are receiving a government or private benefit that are needs based, and we want to supplement but not supplant, impair, or diminish any forms of government or private support that they would otherwise be entitled to receive. So you would do that through a trust share. If you had a revocable living trust, we would just write that into your revocable living trust. If you were leaving money without that, we'd have to kind of do a testamentary SNT share that you make your life insurance beneficiary. But it's easy enough to do. It's just, you're not going to accidentally be able to do it, but it is absolutely the right way to do it. No question about it. Do not do what people try to do on their own and back alley things and say, oh, I'm just going to leave my other two kids 2 shares and this kid no shares, and they'll take care of them. Because even if they're not bad kids that are going to run off with it and not take care of their sibling, which they would have no responsibility or legal right to do. What if they get divorced? What if they get sued and all their money is gone too? Plan for it, and easy to do if you do it right.
Another question is, and I'm pretty sure I know what she's talking about. I've also heard about a 525 for special needs in addition to education, which I believe she's referring to the ABLE account.
Yeah, 529 is what she means. The under the code 529 that deals with the education accounts that we've all known about for saving for college. If you put a little bit of money in when the kids are very young, and it grows tax free, and as long as it's used for a qualified education expense, then you would never have to pay taxes on the gains. And it's a great way to get compound growth over time for college. And then in the 2017 tax cuts that were passed, they extended that education 529 for ages K through 12. If you go to private schools or whatever, you can use the 529s for that. Now, also in the last 5 or 10 years, there's been ABLE accounts, which are also under that 529, and it's for disabled individuals. Must be disabled before the age of 26. But you could save up to $100,000 that would not count against benefits. Now, the strong limitation is it can't be more than $100,000. And also it can only be used, ABLE accounts can only be used for specific qualifying expenses. Whereas a trust-based share and a special needs or supplemental needs trust has far more flexibility, can have far more money in it. So an ABLE account, again, is a nice, quick, and easy way to have a little bit of money go somewhere, but may not be the only or best solution.
All right. And then the third question is, if you have a child with special needs, what kind of planning can be put in place to ensure they get specific care and finances centered to them?
Yeah, and it's all, I mean, you just got to put it in place. So the how to would be, first of all, we need to know what your plan is. And most people do not go so far as to write that down and to make that known to whoever the caregiver would be. And then as far as how to leave the money, again, it would all be so specific to what money we're talking about and what your goals are with that. But if we're worried about any government or private support, your typical goals are going to use a trust share. Again, there are things like able accounts which may be able to do part of it, or maybe even be a part of the overall solution. But that's the best and only way to do that. But I think the point to emphasize on your question that we didn't talk about a second ago was, um, write that down. And those are things that we put in the Guardian Journal. What is the education and care plan? Who do you want to provide the care? And how do you make sure that it happens? Appoint the people that you trust the most to be the people in charge of your plan, whether it be the guardian of your child or the trustee of your trust or the executor under your will or the power of attorney agent under your power of attorney. If you don't trust that the person's going to do what you want them to do, when you've given them all of that information and all the resources to do it, I would suggest naming someone else, that, because unfortunately that's the best way to do it.
All right, and now we have some additional questions.
All right.
So I think these are all from the same person, perhaps. What is the best way to keep all of these documents together and accessible yet secure, just in case they are needed? And then you mentioned the USB drive. So then the question is, how do you carry your USB drive? What if you are unconscious? How do they access it if it is password protected?
Yeah, so all those things are great things. And so I've talked to security experts because these days, I mean, it's so hard. What I can tell you is the the least of my concerns is the one that people used to be concerned about the most, which is, what if my house burns down and all my documents are in it? Um, do I need to get it in a safe deposit box or do this? And the answer is no, because we can do electronically. A lot of times the law firm that you use, and certainly ours, would have all of the documents in. And even if all the originals burned down and you died in the house fire, we would have access to those. Now, you'd make it a good point too about how do we have access to them? What if we're in an emergency situation? Things like wills and the trust and things like that aren't necessarily going to be I need it in 7 minutes situation, but the power of attorney and your healthcare documents certainly can be. I don't recommend using safe deposit boxes or even safes that no one knows the combination to. I would tell the people that would be notified, your emergency contacts, hey, if anything happens to me, this is where I keep my documents and how you get into them, whether it's this is where I keep my USB and this is the password, or this is the combination to my safe. But yeah, a bank safe deposit box is not the best way, because inevitably something's going to happen Saturday at 1 o'clock and you're not going to have access till maybe Monday morning, if you don't have an electronic version. Originals are almost never needed as long as they are scanned, signed, notarized, power of attorney and healthcare documents. So that's why I used the flash drive. I had one client that was visiting a grandson in Oregon for his college graduation, had a medical emergency, went to the hospital. She had the flash drive in her purse and gave it to the hospital. They were like, oh my gosh, this is so amazing. She came back, told you the story, how it has all of our contact information, but says my legacy card on it and all these things as well. I carry mine in my car. Before I had a flash drive, I told my mom, keep the medical the folder with the powers of attorney and stuff in your car if you're still driving around. Otherwise, just somewhere accessible in your house is probably the best you can do. And give copies to, if you're not hiding anything, give copies to whoever would be in that position. Say, hey, I've done this. And last point I'll make about that, the securities expert that I asked about that, because people are saying, what if my computer gets hacked? And that's one of the reasons we use the flash drive, is because it's not attachable by the hackers. But said one of the safest places to keep passwords is on a piece of paper in your house, because the people that are breaking into your house are not the same people that are breaking into your passwords, and vice versa. They also have these two-factor authentication, LastPass, and things like that, where you can keep passwords. But that's my suggestions.
All right. And if you create these planning documents when your children are young, how often do you typically need to update these documents while they're still minors?
Yeah, great question. I meet with any client that I have on retainer. I meet with every single year. Even if we're not changing the documents, I want to update. Maybe you opened an account or closed a different account, and now we're looking somewhere else that if you didn't come home, I'd be able to direct them to that. Maybe you bought a new car and you forgot to add your trust as a TOD beneficiary, or whatever the situation may be. For those that aren't on the annual retainer, I want to be at the ready at all times. And sometimes this works better for young families. Every 3 years is kind of the typical situation, but of course, don't wait 3 years if something drastic changes in your health, your financial situation, or your family situation. So that's generally what I would say. But even at 3 years, there's nothing magic. I mean, it's not necessarily every time there's a new presidential election that laws change. Every year, things could change. Your family situation obviously could change at any time, but hopefully that gives you a good idea. If it's been 3 years and you have stuff, that it would definitely be a good time to revisit no matter what.
Well, that was all of our questions, and we
Awesome.
had a couple of comments thanking you for
Oh, thank
bringing up some key pieces that were very helpful to folks. So appreciation for your time and your presentation. All right.
All righty.
Thank you, everyone. Thank you, Paul.
All right. Thank you.